ऐसे और वीडियोस के लिए मेरे चैनल को सब्सक्राइब करें। 3, 2, 1, start.
Thereafter, the speaker fixed, for examination / cross examination of Shri Kuldeep Bishnoi, MLA, and his witnesses, and on the said date, Shri Bishnoi's evidence was tendered and recorded, full stop. However, his cross examination could not be completed, and the next date for further cross examination of Shri Kuldeep Bishnoi was fixed for 6th June 2011, full stop. In between, on 2nd June 2011, the matter came up before the division bench of the High Court when directions were last for hearing of the petitions at least every week, that is, at least 4 times in a month, full stop. However, on account of the sudden demise of Chaudhry Bhajanlal, MP and former Chief Minister of Haryana, and also the father of Shri Kuldeep Bishnoi, the disqualification petitions were adjourned by the Speaker, full stop. On 21st June 2011, the Speaker fixed all disqualification petitions for hearing on and for further cross-examination of Shri Kuldeep Bishnoi, full stop. The cross-examination of Shri Kuldeep Bishnoi was concluded before the Speaker, and 5th August 2011, was fixed for recording the evidence of the MLAs, full stop. On 18th July 2011, letters patent appeal number 366 of 2011 and other connected matters were listed before the division bench of the High Court, full stop. The said appeal was heard on 3 consecutive days when judgment was reserved, full stop. In the meantime, proceedings before the Speaker continued, and since the same were not being concluded in terms of the assurances given, the division bench of the High Court directed the Speaker to file an affidavit on or before 11th November 2011, full stop. Finally, being dissatisfied with the progress of the pending disqualification petitions before the Speaker, the division bench took up the latter's patent appeals on 2nd December 2011, when directions were given for production of the entire records of the matter pending before the Speaker, full stop. On 7th December 2011, the relevant records of the proceedings before the Speaker were submitted to the High Court, which adjourned the matter for further consideration, full stop. However, as alleged on behalf of the appellants, the bench was not constituted on 19th December 2011, and without any further counsel or hearing, an opportunity to the Speaker's counsel to make submission on the status report, the High Court proceeded to pronounce its judgment on the letter's patent appeals, full stop. By its judgment, which has been impugned in these proceedings, the division bench upheld the directions of the learned single judge also, full stop. However, while disposing of the matter, the division bench stayed the operations of the orders passed by the Speaker on the merger of the HCG with the INC dated 9th November 2009, full stop. It also declared the 5 MLAs, who have filed separate appeals before this court, as being unattached members of the assembly with the right to attend the sessions only, full stop. It was directed that they would not be treated either as a party of the INC or the HCG party, with a further direction that they would not only hold any office either, full stop. It is the aforesaid directions and orders which have resulted in the filing of the several special leave petitions before this court by the Speaker and the 5 concerned MLAs, full stop. As a consequence of the order passed by the division bench of the High Court, 5 independent appellants before us have been prevented from discharging their functions as members of the Haryana Vidhan Sabha, even before the disqualification petitions filed against them by Shri Kuldeep Bishnoi could be heard and decided, full stop. appearing for the Speaker of the Vidhan Sabha, who is the appellant in the appeal arising out of SLB number 54 of 2012, Mr. F. Nariman, Solicitor General of India, contend that this was not a case where the survival of the government depended upon allegiance of the 5 MLAs under consideration, since government was formed with the support of 7 independents and 1 MLA from the Mahujan Samaj Party, full stop. In fact, the 5 MLAs, against whom disqualification petitions are pending consideration before the Speaker, were not part of the government when it was initially formed. Mr. Nariman contended that the learned single judge decided the issue of merger in terms of paragraph 4 of the 10th schedule to the Constitution, by holding that the two orders dated 9th and 10th November 2009, were not final or conclusive, and that, in any event, when the disqualification petitions came to be decided, it would be open for the Speaker to reconsider the issue of merger, full stop. The learned Solicitor General emphasized the fact that there was neither any appeal nor any cross-page objection in respect of the aforesaid decision of the learned single judge, and even if the same fell within one of the exceptions indicated in Bansari versus Ramphal, the judgment must still be held to have become final between the parties, full stop. The learned Solicitor General urged that all the decisions which had been are earlier to this judgment.